Camelot Apartments versus Zachary Layton. Are they here?
Mr. Layton's out there, block was here.
Oh, okay, I did see him. I'll call that later.
Yeah.
Okay. Let's see. FR Lansing versus Michael Flanigan, 26-00613.
Oh, he's on that one too.
Oh, he's on that one too. Got it. Oh, Brown and Brown. Got it. Winter Flats versus Adrian Evans, 26-01320. Have your appearance, please.
Good morning, Your Honor. Sunshine Hart, P69542, on behalf of plaintiff, Ventnor Flats.
Your name, sir?
And
Okay, I have a consent judgment today. Judgment entering consent for the past due amount of $181.38. Please pay the rent. Pay the rent, past due rent.
No, Judge. Past due rent, $2,792. Court costs of $181.38.
Everything else on here is blank. It just says $181.
Oh, I apologize, Judge.
Yeah, that's why I was.
Did I get that? Oh, thank you, Your Honor.
I'll call that when you're finished. Okay. What matters, Mr. Woody, here on? On which one?
Edward Rose, Waverly Park.
Edward Rose versus Isaac Benson. That one. 26-01362. That's a flat out dismissal. Not a conditional dismissal.
No, it's just a straight dismissal.
Oh, he has vacated. Got it. Thank you. Council, which matter are you here for?
For Capital Commons versus Lauren Walker, we have a conditional dismissal signed.
Sorry, didn't I just do an eviction with her last week? Did I miss it? I do remember. Did I do an eviction? She did an agreement. Oh, no, I think they were gonna do a conditional dismissal based off an agreement you had, correct, ma'am?
Yes.
Okay,
May I approach, Your Honor?
yes, thank you. It was a last chance agreement, got it, that's exactly what I remember, okay. State your name for the record,
Jay Day, P36820 on behalf of plaintiff.
and your name, ma'am?
Lori Walker, Your Honor.
Okay, so I remember using this last week, there was an issue or concern regarding use of a key fob. There was a last chance agreement, and it was supposed to be put into a conditional dismissal, which I do have here, and an attachment to the last chance agreement. For the record, your position is that you have not been responsible for making, or giving access to this other person to the property. Is that my understanding?
No.
That's not that's not accurate.
I guess that's what
You're saying you're not responsible for his access?
I'm not responsible for him stepping on the premises.
No, that's not what you told me last week.
Okay, I just.
Yeah, last week you told me that he was at the property when you weren't there and that you're not the one giving him access.
I didn't access. But see, they just run, Your Honor, when folks come in.
I'm not
But I'm
lost on how it works in an apartment
I'm
complex.
sorry.
I grew up living in an apartment complex. I had a key fob to get in. I know how it works.
Yeah.
What I'm asking you, and
Yes.
people didn't get in on my key fob.
Right out.
So, and people didn't get in just because I opened the door. If you didn't live there and I opened the door, I didn't let you in. You can call whoever you're looking for, but what I'm asking you, because you represented to the court that you lost the key fob and you reported it lost, and that they're holding you responsible. Are you still, is that still your position?
No, because I found my key fob.
Okay, so then, so what you said last week was not accurate. You are taking responsibility for someone else getting access to the property. And that's the basis of this
Yes.
last chance
Yes,
agreement.
Your Honor.
Okay, very good. Okay, so it says here that based on this last chance agreement, the matter will be dismissed today. Any non-compliance with the attached agreement is grounds for for the plaintiff to move forward with a judgment against you. You understand that?
Yes, Your Honor.
Okay, and you've signed this last chance agreement.
Yes, Your Honor.
You actually signed this or entered this last chance agreement. My understanding is it before you even came to court,
Yes, Your Honor.
before you were advised of your rights.
Yep,
Before you knew that you had the right to an attorney,
yep.
before you knew that you had the right to proceed to a trial.
Yes, Your Honor.
Okay. How do you want to proceed with this last chance agreement? I think they did that way for on purpose.
Okay, well,
You had the right to be, they initiated an eviction against you, then ran and entered into an agreement the day before you're supposed to be advised of your rights. If you want to withdraw this contract, we can do that at that time. This is the only time I'm allow you to do that.
No, Your Honor. Thank
Okay.
you.
You understand your rights.
Yes, Your Honor.
No one's forcing you to waive your rights.
No, Your Honor.
No one's promising you anything other than what's stated here to get you to waive your rights.
Yes, Your Honor.
You have 3 business days from today's date to return to the court and request to have this set aside if you later realize you misunderstood your rights, okay?
Yes, Your Honor.
We'll get you a copy of this paperwork. Any additional matters for the record, counsel?
No, Your Honor, thank you.
Thank you. You're all set.
Have a blessed day.
Same to you. Back on the record of Flats versus Adrian Evans, and it says here, past due rent to retain is $2,792 plus court costs, $181.38, for a total past due $2,973.38, that you can pay that or vacate of the property by April 13th, 2026, correct?
Yes.
Okay, you understand that you had the right to be represented by an attorney at this eviction proceeding?
No, I did not.
Okay, did you have a pre-trial?
Yes.
Okay, so we advised you of your right to be represented by an attorney. We played a video, you remember that?
Wasn't listening.
Oh, you weren't listening?
I was listening.
Oh, I went on the record and asked you, did you understand your rights? You told me, yeah.
My son is missing. If, there's LPD.
Sir, I'm not asking you that. I'm asking you about your rights, and no, we're not doing that. I asked you, you talking over me. I asked you a direct question for a reason. The law does not allow me to move forward unless I do things in a fashion and form in which they were done. We played your rights, which the law required. I then asked you if you heard your rights. You told me yes. Are you now saying you didn't hear your rights?
Ma'am.
It's a yes or no.
No, I didn't.
Okay.
I'm going through a lot of things right now.
I'm going through a lot of things too. I didn't ask you what you were going through. Sir, I'm just trying to understand. Why would you lie to the court and tell me that you heard your rights if you did it?
Because I was actually on the phone with CPS at that time.
You were on the phone in the
Yes.
middle of a court proceeding?
My son is missing. I don't know. I'm a single father. My son is missing from his mother's side. CPS called me, detectives called me, so I was.
Your son is missing from his
Yes,
mother's side.
yes.
I don't know what that means.
My baby mama had my son. I was
Okay.
at work. CPS called me, and for the past 2 or 3 weeks, we've been on the phone back and forth trying to communicate a game plan. As far as we all know, CPS, LPD, and myself, my baby mother is hopping from house to house in between Lansing and Dansville, hiding my son. So
Okay, so it sounds like the son's not missing, but the son, what you believe is the son is with the mother. I'm just trying to understand. Is that your understanding?
CPS told me they wanted to take him out of her care. So that's why she's up and hopping.
She has custody of the
Not
child.
anymore.
No,
Not
so-
anymore.
So what do you mean CPS said they wanted to take her out of your care?
She took him out. They took him out of her care and placed it in the grandmother's care on the mama side.
So you don't have custody of the
I do
child?
have custody.
Who? That's not what you're telling me.
I'm telling you what they're telling me. I'm at work. They called me.
You know
and
him,
said-
sir? Oh, okay, I was
No.
concerned.
They called me and said, hey, we took your son from, do you know where your son is at? No, and he with his mom. at
You
school.
have full custody of your child.
It's 50-50.
Okay, that was my question. Okay, so she has shared custody, and so he could have lawfully been in her possession, is what you're saying.
That's not what they're telling me, but I'm hearing you.
No, I'm asking you. I don't know. I'm not a party to this.
They're telling me that they took him out of her care to place him in the mom's care until they contact me or whatever the case may be. And then Next thing you know, I get a call while I'm at work at the hospital saying, hey, do you know where your son is at? No, he's with his mom last I knew. Oh, he's at school. He's not going to school. He's not with his mom nor grandma.
Listen, sir, I recognize that you got a lot on your plate. If you think that you're the only person in this courtroom with a lot on your plate, then you're misguided, okay? You were not on the phone when I conducted the proceeding. You were not, because I will not allow anybody to be on the phone. And I make sure your video is on so that I can see what you're doing in the first place.
That's cool.
I know it's cool. That's how I run this court. And so I asked you specifically about your rights. These rights are not to protect me, they're to protect you.
Understand that.
And so regardless of what is going on outside of that, you still have an eviction.
I got that.
And you still have to understand your rights.
I'm here for that. And I said I didn't know I can have an actual lawyer today at this time.
At every court proceeding for this, you have the right to an attorney.
I'm ready to go.
No, you're not ready to go until I say you're ready to go. Did you understand that you had the right to have an attorney?
Today, no, I did not.
Okay, and so you have a seat, because I will now have to re-go over your rights before we can proceed. We're still working with Mr. Bach. Is that correct? Doc's not here on the FR Lansing versus Michael Flanigan, right? No.
No, yeah. Yes, Mr. Bach is here.
Oh, okay. Who's here on FR Lansing versus? It says Michael Flanigan. I have Patricia Flanigan here. What's happening?
No, yeah, no, here.
Okay, this is 26-00613 LT. Appearances, please.
Morning, Aaron, I'm back here for the 20.
Good morning, Your Honor. Stuart Oliver, P. 7707 for the defendant, Patricia Flanigan.
Okay, are you not representing Michael Flanigan?
Your Honor, Michael Flanigan, the named defendant, is deceased, so we are, it's my understanding that plaintiff is submitting a dismissal on that one.
Yes.
Okay, because the other Michael Flanigan is a junior, is that what the issue is?
Yes, yes.
Do you have a dismissal for that?
I do, may I approach?
Yes. Okay, and what about the other Michael Flanigan who said he lives in the property and he appeared at court? But you're not representing him?
No, Your Honor.
Okay, did you enter an agreement with him? Because he appeared in court. He appeared in court twice. We need to operate under an all other occupants. He's appeared in court twice and given his name to the court, which is the same as the other man, but there needs to be something for him.
Well, we do have a CD with Patricia Flanigan and all not being a main leaseholder.
But he's occupying the property. It's only, that's for your client's protection, not mine. You're okay
Well,
with that?
that's why we should have said all,
Okay. What if she moves out and he doesn't?
but he's an occupant. That protects,
You won't have anything with his name on it.
that protects the process server and us.
You won't have anything where his name, with his name on it. He could just be a squatter. You have to start all over. If he's squatting. You'll have nothing to prove that he didn't come in and squat after she moved out. You have nothing to prove that if you don't get his name on something.
My understanding is some court officer out to do the eviction. If there's
Yeah, you would get, yeah,
anything in the property and it
Right.
says all occupants, they can move everything and everybody out.
look, no, because squatters have rights. We know that, right? A squatter could come in after you executed eviction. It could be Jimmy Dean that comes in and moves in there. All other occupants doesn't apply to him. You gotta start a whole new eviction against him. What I'm saying is, by not taking the opportunity to put his name on something, you put yourself at risk or your client at risk.
I
And
understand.
so he's here today. Did we want him in the paperwork while he's here?
Well, not that one, but maybe this one. We could add his name to the CD.
Okay,
That's a dis-
I have, go
That's a
ahead.
dismissal for the deceased.
I also have a CD.
We give her that CD.
Yes.
Oh, we did. Oh, okay.
Okay. So you would like to add his name as well?
You said yes.
You can come around, sir. And you're Michael Flanagan Jr.
Correct.
Okay, so this is a conditional dismissal. It says that you will vacate, I'm assuming what this says, before April 20th. Is that correct?
Yes, ma'am.
Okay, and vacate means you're gonna take all of your property.
Correct.
I'll leave the property in room swept condition.
Yes,
You're not leaving trash and things behind for them to have to remove. You understand that?
correct.
Okay. And you understood that you had the right to be represented by an attorney at this proceeding,
Yes.
and you waived that right?
No, I thought she was representing me too, but
Okay,
that's way washed out.
okay, but she's not. Now you do understand that. So are you gonna waive your right to be represented by an attorney? Okay. And then you also had the right to proceed to a trial. You could have had a jury trial on this. You both understand that?
Yes,
And you want to waive that right?
yes.
Anyone promising or threatening you to get you to waive those rights? Okay, you have 3 business days to return to the court and have this set aside. If you later realize you misunderstood your rights, you can request to have a hearing to address that. I'm going to sign the dismissal for Mr. Michael Flanagan Senior. You'll get a copy of the paperwork in just a moment. Thank you.
Thank you.
No problem. You're here also in Jolly Flats versus Mercedes Williams. Oh, that's you. What's your other matter, Mr. Bob?
Is Camelot.
Oh, Mr. Layton, that's right. Okay. Let's see, Jolly Flats versus Mercedes Williams and all other occupants. 26-01324 LT appearance, please.
Good morning, Your Honor, Sunshine Heart, 69542, Jolly Flats.
Your name, ma'am?
Mercedes Williams.
Okay, today was the date scheduled for a hearing. This is for non-payment of rent. I do have a consent judgment. It says that past due rent is $1,667 plus $180.29 for cost, for a total amount due $1,847.29. That you'll pay that balance in full or vacate the premise by April 13, 2026. Is that correct? Is that a yes?
Yes.
Okay. You understand that you have the right to have an attorney represent you?
Yes, ma'am.
Do you want to waive that right? You also have the right to proceed to the trial. You could have had a jury trial. You understand that? And you want to waive that as well? Anyone threatening you to waive these rights? Any promises to get you to waive these rights? Is that a no?
No, ma'am, sorry.
Okay, no problem. There's a record, and so they have to, it has to be clear, that's all. Okay, you have 3 business days to return to the court and request to have this set aside if you later realize you misunderstood your rights. I will get you a copy of that paperwork in just a moment, okay?
Thank you, Your Honor.
You're welcome.
Judge, I believe the defendant would like to address the court.
Yes. Oh, thank you. Thank you. You can have a seat right there. He's gonna get you the paperwork in just a moment. I think she's fixing the printer. Out here, all right. You can have a seat right out there. Mr. Evans, if you want to pay attention to the screen, you're fine right there. I'm gonna play your rights for you. There, I'm gonna play your rights for you. Oh, there's something playing in the background. Give me just a moment.
Welcome to the 54A District Court. Please listen carefully for information about your rights and resources that may be available to assist you. Please have paper and a pen handy. You have a right to retain an attorney to represent you. If you do not have an attorney and you can afford an attorney, you might locate an attorney by calling the State Bar of Michigan at 1-800-968-0738. If you are a tenant and you cannot afford to hire an attorney, you may seek free representation from legal services. You should have received this information with your summons and complaint. There may be a representative from legal services available today to speak with you. You have a right to proper venue. If your residence is not located in the city of Lansing, you have a right to ask the court to transfer the case to the district where the property is located. You have a right to a jury trial. If you want a jury trial, you must request it orally in court today, or you may file a demand within 5 days. You are also responsible for paying the jury trial fee unless you have requested a waiver. Assistance may be available from the Michigan Department of Health and Human Services, the local coordinated entry agency, or Abbott House. Those agencies may be able to assist you with payment of some or all of the rent. You do not need a judgment for assistance. The summons and complaint are sufficient for your request for assistance. If you have served in our armed forces, assistance may also be available for the Michigan Veterans Trust Fund. Please call 1-800-642-4838, option 6. If your case is a non-payment case and you have already applied for assistance from one of the agencies, please be sure to tell the judge. You will be required to submit written proof to the court within 5 days. Your landlord-tenant case can be resolved in a number of ways. One way to resolve this case is if you and your landlord reach an agreement. In such case, a conditional dismissal is possible when approved by all parties. The court can provide you with a form for a conditional dismissal. Another resource is the Michigan Community Dispute Resolution Program. If the court determines that your case can be resolved through community dispute resolution, then that resource will be coordinated by the judge. Information about your other rights and the legal process is also available from the Guide to Michigan Legal Help at www.michiganlegalhelp.org. Thank you for your attention. Your case will be called shortly by the judge.
back on the record in the matter of Venture Flats versus Adrian Evans. Mr. Evans, we did replay your rights for you. Did you hear your rights?
Yes, and I have a few questions.
Yes.
Can I do what was it, continual dismissal or agreement dismissal with them? Like after today, if I go down there and talk to them,
You want to do a conditional dismissal?
yeah, like.
It's not an option.
Is
That
that
was
a
that
thing?
in slots, Judge.
Okay, yeah, that's it. For some reason,
I didn't even know that was a thing.
that's why I wanted to make sure you heard your rights. For some reason, some of the landlords are not offering conditional dismissals. I don't know why. But you have to waive your rights before you can move forward, and you have to understand your rights before you can move forward, which is why I cannot move forward if you're telling me, hey, I wasn't paying attention. And so a conditional dismissal is not an option. I don't know if you have an intention of paying this or vacating
I'm definitely paying it because, yeah, definitely paying. That's why I wanted to see.
before the 13th.
Yeah, most
Okay.
likely.
What is the position? Why is it that Venture Flats won't do a conditional dismissal?
Because we have to draft an affidavit and then the reinstatement package, which costs them money for us to have to do that.
You have to
Instead of
draft a packet and a reinstatement?
just- Correct. So for conditional dismissals, before we can reinstate the case, we get an affidavit from the client, the ledger, saying how they didn't make the payments or whatever was agreed upon in the conditional dismissal. So we charge them, I think, $250 to draft the affidavit. They sign it, get it back to us. They think the process is longer and it's costly to them on their side. So that's.
Oh.
what they are, but-
Okay. You're gonna pay for the 13th?
Mhm.
We set this after the 13th. That's to me ridiculous to do tenants that way.
Can do April 15th at 9:30.
April 15th at 9:30. We'll keep this in case you decide on that date that you want to move forward with a consent judgment, okay? If you pay in full, including the fines and costs, understanding that today's the first, is that include the
Mhm.
first rent?
That's not judge.
Yeah, your new rent is coming accrued as well. You understand that, right?
Well.
You gotta pay all of it.
Can you tell me the number on that paper? Because I just got a message
This-
from my rent and it sounded just about that.
It says $2,973.38, and that includes the court costs.
This month's rent too. I just got a message this morning
Oh,
sitting out
that is-
there.
That is correct, Judge. It would be this month.
Oh, okay.
Yes.
So you have to pay all of that before the next court date, and they can dismiss it, okay?
Okay.
Any additional matters for the record?
Nothing additional, Judge. Thank you.
You all could appear via Zoom for that.
Thank you, Your Honor.
Yeah, I'm gonna give you.
Yep,
Thank you, Your Honor. That
Thank
closes
you.
the council. Have a great day.
thank you, same to you. Let's see, and best wishes about your child, sir. Let's see here. This is a fail to comply. We only have one more in Layton. I was gonna say two, because Layton. Okay, on the record in the matter of Camelot Apartment Management versus Zachary Layton, this is 25-08358, council appearance.
Good morning, I'm Ron back here for the Lane.
Your name, sir. Okay, this matter was adjourned so that you all can continue to resolve some issues and possibly negotiate a settlement. I do have a consent order for conditional dismissal here. It says past due rent is due the amount of $1,850 with court costs $259.64 for a total due $2,109.64. That's for rent due through a period of April 30th, 2026, correct? That's correct.
Yes,
Okay, it says defendant shall pay $850 by the 10th of April. If $850 is paid by April 10th, plaintiff will credit an additional $1,000 to defendant's balance and agree to move defendant. Let's see, is this defendant's agreeing to move?
Yes.
Oh, okay, it doesn't say that, it just says and agree, okay. Defendant agreed to move and vacate by the 30th, correct?
Yes.
Okay, otherwise vacate day stays in for until the 10th. So if he doesn't pay the money, he's got to vacate by the 10th. That's what you're saying?
yes.
Got it. Okay, you understand that? Okay,
Judge,
yes.
one thing I forgot, we need to mention that the counter complaint is dismissed.
That's correct.
Yes.
Okay, and so you understand that you have the right to proceed to trial on this, correct? You also understand the right to have an attorney, correct? You're waiving those rights. And then partial payment won't satisfy this, so you gotta pay the $850 by the 10th. You understand that?
I'll have that today, Your Honor.
They'll have it today. Very good. You have 3 business days to return to the court and request to have this set aside. If you later realize that you misunderstood your rights, you can set it for hearing, okay?
Yes, ma'am.
I'll get you a copy of the paperwork. Thank you for working diligently to resolve your issues. Best wishes to you.
Yes, ma'am, Your Honor.
This one there? I'm just gonna shred it.
All right, so.
Good to see you.
All right, so.
And then Steve's at your apartment right now. He got there like 10.
Love, early good.
He's
Late, I'm
got-
saying
wait,
late.
wait.
That's why I probably answered. You told me the wrong name.
Jesus for leaving me.
Sorry.
No.
Of course, thank you. Appreciate you so much.
Sure you beat this.
To the next one, right?
All right, but.
You know, 99% of these.
I think I've had 3 tenants so far do jury trial with me.
Oh,
This is it Camayo Properties versus Ajon Ziwale, an emergency response sold 26-00373. Can I have your appearances, please?
Good morning, Your Honor. Roger Smith and Brian Lum appearing on behalf of Martin Commercial, agent for Camelot Properties LLC.
Billy J. O'Berry on behalf of Ajon Ziwale, appearing on behalf of Emergency Response Resolutions.
Okay, today was the date scheduled for hearings. This is for non-payment of rent. And I thought that you all were going to come to a resolution that was not able to happen.
No, Your Honor, I was retained towards the end of this, just not too long ago in this matter, and I have received documentation from the defendant, from City of Lansing Fire Department inspections, various documents from related to the condition of the premises. And I actually have not had an opportunity, I just received those, an opportunity to even present them to the plaintiff. We did talk about a conditional dismissal, but we were just not there at this point because of some of those kinds of issues. And I woke up, I think I must have scratched my eye in the night or something, and I'm just having issues with vision today, and it's not going very well.
So it sounds like this needs to just be reset so that you all can have more time to work this out and deal with the discovery issue.
Yes, and I had mistakenly thought that he was already out of the property. Thought that he was already out of the property, and I was mistaken about that. He has moved some things out, but we've talked about that, and I have assured plaintiff that I will be getting him to vacate the premises just as quickly as possible.
Okay, I'll just reset this for the next available date.
Thank you.
April 15th at 9. Does that work for both of you?
It's tax deadline day. Is there
You have a different date?
any possibility? The only problem is
There's no direct conflict in that date. We want that. Yeah, my client was trying to get it as soon as possible.
okay, 9 a.m. on the 15th, then, Your Honor.
Hopefully you all will have resolved it and then you won't be dealing with it. Hearing, it does sound like you all were working diligently to try to get it resolved.
It's right.
Any additional matters for today?
Not from the plaintiff. Your Honor.
And I do appreciate their courtesy, Your Honor, in this matter. So
Thank you.
Thank you.